Good day, Dean and classmates. So for this part, we will be discussing about the revised guidelines for continuous trial. So for our discussion, we will be tackling about its applicability, the objectives, and as well as the procedure. So the revised guidelines for continuous trial shall apply to all newly filed criminal cases. This includes those that are governed by the special laws and rules in the first and second level courts, the Sandigan Bayan, and the Court of Tax Appeals. Now this shall also apply to pending criminal cases with respect to the remainder of the proceedings. And these guidelines shall not apply also to those criminal cases which are filed on the rule on summary procedure, except if it is specifically provided. So now we go to the objectives. Here there are three given objectives. First is to protect and advance the constitutional right of persons to a speedy disposition of their criminal cases. Second is to reinforce and to give teeth to the existing rules on criminal procedure and other special rules which prescribe periods for court action and those which promote speedy disposition of criminal cases. And lastly is to introduce innovations and best practices for the benefit of the parties. So for the procedure proper, first is the hearing days and calendar call. So the trial shall be held from Mondays to Thursdays, and the court shall call the cases at exactly 8:30 a.m. and 2 o'clock p.m. Now, hearing on motions, arraignment, and pre-trial and promulgation of decisions shall be held in the morning of Fridays. All courts should ensure the posting of their court calendars outside their courtrooms for at least one day before the scheduled hearings. So now we go to motions. The first one is motion for inhibition. Now these motions are based on the grounds which are found under Rule 137. These must be resolved immediately or within 2 calendar days from the date of filing. Next is prohibited motions. Now these motions are denied outright without the need of any comment and or opposition. So the following are considered as prohibited motions. First is motion for judicial determination of probable cause. Second is motion for preliminary investigation if it is filed beyond the 5-day regulamentary period in inquest proceedings or when preliminary investigation is required. Also, when it is allowed in inquest proceedings but the accused failed to participate despite due notice. Next is motion for reinvestigation. If it is filed without leave of court, or when the preliminary investigation is required, and when the regular preliminary investigation is required and has actually been conducted, but the grounds relied upon in the motion are not meritorious. Next is motion to quash information when the ground is not one of those stated in Section 3, Rule 117. Another prohibited motion is motion for bill of particulars that do not conform to Section 9, Rule 117. Another one is motion to suspend arraignment and petition to suspend the criminal action on the ground of prejudicial question when no civil case has been filed. Lastly is the motion for postponement unless based on the acts of God, force majeure, or physical inability of the witness to appear and testify. Now we go to meritorious motions. These are motions which allege plausible grounds which are supported by relevant documents and or competent evidence. However, this does not include those which are already covered by the revised guidelines. So the following are considered as meritorious motions. First is the motion to withdraw information or to downgrade the charge or to exclude an accused originally charged therein. Second is the motion to quash warrant of arrest. Third is the motion to suspend arraignment on the ground of an unsound mental condition. And motion to suspend proceedings on the ground of a prejudicial question where a civil case was filed prior to the criminal case. Another meritorious motion is the motion to quash information on the grounds that the facts charged do not constitute an offense, lack of jurisdiction, extinction of criminal action or liability, or double jeopardy. Next is motion to discharge accused as a state witness, and the motion to quash search warrant under Section 14, Rule 126, or motion to suppress evidence. And lastly, motion to dismiss on the ground that the criminal case is a strategic lawsuit against public participation under Rule 6 of the Rules of Procedure for Environmental Cases. Guidelines are also provided in terms of free legal assistance, in which, if a party fails to qualify in the availment of services of the Public Attorney's Office, the IBP local chapter shall then provide for legal assistance. However, they must submit to the executive judges a list of IBP local lawyers who may be appointed to act as counsel de officio, and this list must be disseminated among all the trial courts. Now, if a private prosecutor prosecutes only the civil liability in a case, a written authority has to be issued by the head of the prosecution office in favor of the private prosecutor to try the case, even in the absence of the public prosecutor. Now, this written authority must be submitted to the court prior to the presentation of the evidence. For consolidations of newly filed cases, the executive judge shall cause the raffle to only one court, which shall then resolve the said motion. Now, for those pending cases with multiple accused, the subsequent case shall no longer be raffled and shall be assigned by the executive judge to the court where the earlier case is pending. Now, if the earlier case is already at the trial stage and witnesses have already been presented, the parties may be allowed to adopt the evidence so far presented without prejudice to the additional direct examination questions and cross-examination questions. A criminal case shall be archived only in the following instances. First is if after the issuance of the warrant of arrest, the accused remains at large for 6 months from the delivery of the warrant to the proper peace officer. Second is when proceedings are suspended for an indefinite period due to the following reasons: that the accused appears to be suffering from an unsound mental condition, or that a valid prejudicial question in a civil action is invoked during the pendency of the criminal case, or that an incident in the criminal case is elevated to and is pending resolution or decision before a higher court, and lastly, when the accused has jumped bail before arraignment and cannot be arrested by the bondsman. For provisionally dismissed cases, provided that no revival was made, those offenses which are punishable by imprisonment not exceeding 6 years or a fine of any amount or both shall become permanent 1 year after the issuance of the order. However, for those offenses which are punishable by imprisonment of more than 6 years shall become permanent 2 years after the issuance of the said order. Now we go to the guidelines which involve the arraignment and pre-trial. The schedule of the detained accused must be set within 10 calendar days from the date of the court's receipt of the case. For the non-detained accused, it must be made within 30 calendar days from the date the court acquires jurisdiction. Now, the notice must be sent to the accused, the counsel, the private complainant or complaining law enforcement agent, the public prosecutor, and the witnesses. As to the reading of information, waiver is allowed provided that there is a full understanding and express consent of the accused and his or her counsel, and that such is expressly stated in both the minutes or certificate of arraignment and the order of arraignment. For the arraignment proper, if the accused desires to enter a plea of guilty to a lesser offense, plea bargaining will proceed, provided that the private offended party or arresting officer is present to give his or her consent. However, if a plea of guilty to the crime charged in the information is given, judgment will immediately be rendered, except in cases which involve capital punishment. If no plea bargaining or plea of guilty is given, arraignment and pre-trial will immediately proceed. Arraignment and preliminary conference shall be simultaneously held, and the court shall take up all the matters required under Section 14, Rule on Summary Procedure during the preliminary conference. In the conduct of pre-trial, in case of the absence of parties, the pre-trial shall proceed provided that the counsel for the accused and the public prosecutor are present and that the accused and or private complainant were duly notified. However, on the stipulations, it must be done with active participation of the court and not merely by the counsels. As to the marking of evidence, documentary evidence should always be marked. Now, pre-trial order must be immediately served on the parties and the counsel on the same day after the termination of pre-trial. The rules must be strictly complied with and to be observed in the conduct of pre-trial. The following are cases which are referred to mediation on civil liability. First is crimes where payment may prevent criminal prosecution or may extinguish criminal liability. Second is crimes against property, crimes against honor, libel, criminal negligence, and intellectual property rights cases. Referral to the Philippine Mediation Center unit may be made only after the conduct of arraignment and pre-trial or preliminary conference. It must be terminated within a non-extendable period of 30 calendar days from the date of referral by the court to the PMC unit. After the lapse of the mediation period, or if the mediation fails, the trial shall then proceed. Now we go to bail. So a petition for bail is set for summary hearing after arraignment and pre-trial. It must be heard and resolved within a period of 30 days from the date of the first hearing. However, for drug cases, it must be made within 20 calendar days, even without the need of oral argument and submission of memoranda. Now, for motion for reconsideration, it must be made within a period of 10 calendar days from the date of submission of the said motion. In the evidence in petition for bail, the resolution must be made solely on the evidence presented. Now, the prosecution has to present evidence which is essential to establish that the evidence of guilt is strong. On the other hand, the accused need not present any evidence. Now, for the presentation of evidence, it shall not be suspended while awaiting the resolution. Forms of testimony. For the first-level courts in all criminal cases, which includes those covered by the Rule on Summary Procedure, the testimony of witnesses should consist of, first, the duly subscribed written statements, second, affidavits or counter-affidavits, or judicial affidavits which are subject to additional direct and cross-examination questions. However, on the second-level courts, Sandigan Bayan and Court of Tax Appeals, in all criminal cases where the demeanor of the witness is not essential in determining the credibility of said witness, and those that are transactional in character, the testimony of witnesses must consist of the duly subscribed written statements, the affidavits or counter-affidavits, or the judicial affidavits. For stipulations, the court requires that the parties enter into stipulations on the subject of both direct and cross-examinations of witnesses who have no personal knowledge of the material facts constituting the crime. The subject of the direct testimony of witnesses should be stipulated upon if the stipulations cannot be had in full. In trial, the court shall encourage the accused for the application for examination of witness before trial, and the prosecution for the conditional examination of witness for the prosecution. Now, in case of absence of the counsel de parte, hearing shall proceed upon appointment by the court of a counsel de officio. Now, in terms of the offer of evidence, it must be made orally on the same day after the presentation of the last witness. The opposing party is then required to immediately interpose any oral comment or objections. Now, all exhibits offered cited by the counsel are to be submitted on the same day of the offer. The demurrer to evidence must be filed within 10 calendar days from the date leave of court is granted. Now, a corresponding comment must be filed also within 10 calendar days from the date of receipt of the demurrer to evidence. Now it must be resolved by the court within 30 calendar days from the date of the filing of the comment or the lapse of the 10-day period to file the same. If the accused moves for leave of court to file demurrer to evidence, but the motion for leave is denied, then the court shall issue an order to present and terminate the evidence on dates previously scheduled and shall orally offer and rest the case on the day of the last witness is presented. However, if despite denial the demurrer is still filed, then the previously scheduled dates to present the evidence shall be cancelled. If the motion for leave is granted, but the subsequent demurrer is denied, the accused shall then present and terminate the evidence and shall orally offer and rest the case on the day the last witness is presented. For the presentation of rebuttal and surrebuttal evidence, the prosecution shall immediately proceed with its presentation after the accused has rested his or her case and orally rest its case in rebuttal after the presentation of its last rebuttal witness. Thereafter, the accused shall immediately present surrebuttal evidence if there is any and orally rest the case in surrebuttal after the presentation of its last surrebuttal witness. The court shall then submit the case for decision. Now the court strictly adheres to the one-day examination of witness rule, wherein a witness has to be fully examined only in one day. The filing of a memoranda is discretionary. If it is filed, it should not exceed 25 pages in length, single-spaced on a legal-sized paper using size 14 font. The period to submit is non-extendable and shall not suspend the running of the period of promulgation of decision. On the other hand, judges cannot defer the case for decision on the ground of missing transcript. Stenographers shall submit complete transcripts within a period of 30 calendar days from assumption to office. If the judge is tasked to write the decision, is not the same judge who heard completely the said case. For the promulgation, it should not be made more than 90 calendar days from the date the case is submitted for decision. Now for the resolution of motion for reconsideration of judgment, of conviction, or motion for new trial, it must be filed within the reglementary period of 15 days from promulgation, and must be resolved within a period of 10 days with or without comment. 1 week of each semester is to be allotted for the conduct of annual and semi-annual physical inventory of cases, and a semestral docket inventory report must also be prepared. So that is all for the revised guidelines for continuous trial of criminal cases. Thank you for listening.